जनगण मन अधिनायक जय हे भारत भाग्य विधाता। पंजाब सिंध गुजरात मराठा द्राविण उत्कल वंगा, विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा। तव शुभ नामे जागे, तव शुभ आशीष मांगे, गाए तव जय गाता। जनगण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे जय 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 हे।
Honorable Governor, Shri P.S. Sridharan Pillai, Chief Guest for today's function. Honorable Mrs. Justice Bharti Dangre, Honorable Mr. Justice Valmiki Menezes, Honorable Ms. Justice Nivedita Mehta, Honorable Mr. Justice Abhay Oka, former Judge, Supreme Court of India, the Learned Advocate General, State of Goa, Senior Advocate Devidas Pangam, the respected and distinguished retired judges of the High Court of Bombay and Goa, President, Goa High Court Bar Association, Senior Advocate Coelero Pereira, Senior Advocates, my senior and junior associates, colleagues at the bar, students, and ladies and gentlemen. There is a famous saying by the great junior Martin Luther King, and he said that the ultimate measure of the man is in the moments when he's not comfortable, but it depends on how he stands when the going is challenging and when the going is controversial. We have all gathered here today for the first edition of the annual lecture series. It's a memorial lecture series in honor of late Mr. Justice H.R. Khanna, a man of great resolve, a man of high caliber, a man of constitutional courage, a man of deep knowledge of the constitutional principles, a man who spoke his mind, stood by his values in times when the constitution, or for that matter, the country, was going through turbulent times. And that too at the cost of his career, if one may say so. And I believe it is this sacrifice that led the great Mr. Nani Palkiwala to say that for a man of the stature of Justice H.R. Khanna, the Chief Justiceship of India would add nothing. From a jurist like Nani Palkiwala, I don't think it could be better articulated in terms of the caliber of Justice Khanna, in terms of his stature, his contribution, his constitutional courage. And I would like to believe that it is this constitutional courage that captivated the imagination of the Honorable Governor, Shri P.S. Pillai, to approach or indicate to us that he would like to offer a grant to keep the legacy of Honorable late Justice H.R. Khanna alive. And it is in furtherance of that pursuit that we, as a managing committee, decided to have an annual lecture series. So, from the bottom of my heart, I would express deepest gratitude to the Honorable Governor, Sri P.S. Sridharan Pillai, for this kind gesture. I request for a round of applause. Thank you, Honorable Governor. It just gives us an opportunity to bring to the members of the bar and the legal fraternity and the students the contribution which is not forgotten but definitely needs to be emphasized and overemphasized. In keeping with the spirit and the cherished values, we have Honorable Justice Oka. I don't think we could have thought of a better person to start off the lecture series. Honorable Justice Oka is one of the judges of the highest caliber to have ever served the Indian judiciary. I don't think anybody can put it better than Senior Advocate Kapil Sibal when he said that the greatest judges of India are remembered for their protection of freedom and liberty, and Honorable Justice Oka would be included in that pantheon. So, on behalf of the Goa High Court Bar Association, sir, we are extremely grateful that at short notice you agreed to grace the occasion and give this, the inaugural lecture, the necessary impetus from a judge of your caliber and stature. We have, in keeping with the spirit of the occasion and to felicitate or greet the dignitaries on and off the days, may I request Advocate Anton Carvalho to kindly present the hamper to the chief guest, Honorable Governor Sri Pillai. So, thank you. May I now request Advocate Savio Mesquita to kindly present a hamper to Honorable Mrs. Justice Bharti Dangre. May I now request Gaurang Kerkar to kindly present the hamper to Honorable Justice Valmiki Menezes. May I now request Om De Costa to kindly present the hamper to Honorable Ms. Justice Nivedita Mehta. May I request Prayash Shirodkar to kindly present the hamper to Honorable Justice Abhay Oka. May I request Annalise Fernandez to kindly present a hamper to the Learned Advocate General, Senior Advocate Devidas Pangam. Well, President is the host, so you don't get any hampers. So to set the ball rolling, may I now request the President to kindly give his opening remarks.
Honorable Governor Mr. Sridharan Pillai, Mrs. Honorable Mrs. Justice Bharati Dangre, Honorable Mr. Justice Abhay Oak, Honorable Leonard A.G., Honorable Judges, sitting judges, and retired judges, senior advocates, and my colleagues at the bar. It is my pleasure as the President of the Goa High Court Bar Association to welcome the Honorable Governor of the state, Mr. Sridharan Pillai, Honorable Mr. Justice Abhay Oak, former Judge of the Supreme Court, Honorable Mrs. Justice Bharati Dangre, Administrative Judge of this bench, Honorable Mr. Justice Menezes, Honorable Mr. Justice Nivedita Mehta, Learned Advocate General Pangam, designated senior advocates, and all my colleagues at the bar, students of law colleges, the future lawyers, and other members of the audience. At the outset, let me thank the Honorable Governor, Mr. Pillai, for not only having agreed to be the chief guest for the inaugural of, of late Mr. Justice H.R. Khanna Memorial Lecture, but also for his thoughtfulness and concern for the members of the Goa High Court Bar Association. Although Governor Pillai gave his active practice in the Kerala High Court, he has certainly not forgotten his fellow brethren. I say this because somewhere in the month of March of this year, I received a call from the Learned Advocate General, Mr. Pangam, informing me that the Honorable Governor wished to meet me in my capacity as a President of the Goa High Court Bar Association, and further disclosed that the Honorable Governor wished to donate a certain sum to the Goa High Court Bar Association, and that we could use the sum for any altruistic pursuits that would benefit our members as well as the legal community at large. That summons to Cabo Raj Nivas from the Honorable Governor resulted in him donating a sum of rupees 5 lakhs to the Goa High Court Bar Association, which shall form the seed for a trust which is in the pipeline and shall be shortly crystallized to be used for activities that would benefit the community of lawyers, and this lecture series is one of such activity. I would request again all of you to give a round of applause to the Honorable Governor for this unprecedented gesture and support to the Goa High Court Bar Association. It was during the course of my meeting with the Honorable Governor that I learned that he was an ardent admirer of Justice H.R. Khanna, who at a great personal cost strove to keep up the Dacian principles of rule of law and the sanctity of the Constitution. This led me to believe and understand that we, the people of India, and particularly lawyers, owe an immense debt of gratitude to the late Justice H.R. Khanna, and perhaps the best way to repay that debt, albeit in tiny measure, is to perpetuate his memory by organizing a lecture series to preserve the values embodied while also propagating the values he cherished. Just 2 years ago, we celebrated the anniversary of the judgment in Keshavnan Bharati by bringing out a souvenir which was released by none other than the present Chief Justice of India, Honorable Mr. Justice B.R. Gavai. The judgment in Keshavnan Bharati's case is synonymous with Justice H.R. Khanna, who propounded the doctrine of basic structure. The judgment in St. Xavier's College versus State of Gujarat is another landmark in his repertoire of judgments, where the Supreme Court was called upon to decide the protection of minorities conferred by Article 30 of the Constitution. The consistency in his thought process and independent mind are unmatched. Today's event is a culmination of that meeting. The inaugural of late H.R. Khanna Memorial Lecture on the occasion of his birth anniversary is delivered by Honorable Mr. Justice Oak, who in several ways is an individual very similar to Justice H.R. Khanna. Honorable Mr. Justice Abayok, who will be addressing us on the independence of judiciary, gave up a lucrative practice as a lawyer of Bombay High Court to serve this country as a judge of the High Court of Bombay, as Chief Justice of Court of Karnataka, and finally as a judge of the Supreme Court of India. In my opinion, there is no better person to deliver this address other than him, inasmuch as an examination of his judgments revealed an unbiased testimony to his being a champion of rule of law, as well as a defender of the Constitution and constitutional values. Now, talking about Justice H.R. Khanna, Justice H.R. Khanna hailed from Amritsar, Punjab, and he was born on 3rd July 1912. That's why we are here today to commemorate the birth of this great judge of our country. Having graduated from the Law College, Lahore in 1934, he enrolled as a pleader and practiced in Amritsar till January 1952, when he came to be appointed as a district and session judge, after which he was appointed as a judge of the Punjab and Haryana High Court in the year 62, from where he rose to become the Chief Justice of Delhi High Court in 69. And finally, in 71, when he was appointed a judge of the Supreme Court of India. Justice Khanna, from a reflection of his reported judgments, enlarged the power of judicial review under the Constitution, and thus shows that his was a judicial mind steeped and dyed in Dicey's rule of law. The law of Constitution to him meant the rule of law, which meant Dicey's formulation of it, and then that formulation was as axiomatic as in law as the law of contradiction was axiomatic in logic. Justice Sinha, Chief Justice, was the first to bring in the Dicean principle of rule of law in the famous case of K.M. Nanavati versus State of Bombay. He, whilst delivering a majority judgment, referred to rule of law. While Dicey's rule of law has been largely discredited in England, Justice Khanna stood to his principles and suffered. While following the rule of law, Justice Khanna always kept the doctrine of separation of powers as propounded by Montesquieu in mind. We all know his principal judgment, the bold dissenting judgment in ADM Jabalpur versus Shivkant Shukla cast an unfortunate shadow over his career, and he suffered both professionally as well as personally when he was superseded and was denied the opportunity of proving his mettle as a Chief Justice of India. Nonetheless, he left behind a rich and unparalleled legacy which we are today celebrating. I would not detain you more, and I say thank you to all of you for giving me a hearing, and I'm sure you would like to hear the other speakers on the occasion. Thank you.
May I now request Honorable Mr. Justice Bharti Dangre to kindly address the gathering.
Honorable Governor of State of Goa, Mr. Sridharan Pillai, Justice Abhay Oka, retired Supreme Court judge, my colleague Valmiki Menezes, Justice Nivedita Mehta, the Advocate General of State of Maharashtra, Mr. Devidas Pangam, the President and Secretary of the High Court Bar Association, the retired judges of the Bombay High Court who are present here, all the respected senior counsels, the other lawyers, junior lawyers, and students. A very good evening to all of you. Today we have gathered here to celebrate an illustrious and notable career of Justice Hansaraj Khanna, whose name is woven in the very fabric of the constitutional story, a story of courage, conscience, and quiet defiance in the face of overwhelming pressure. He studied at law at Lahore and began his legal practice with modesty and diligence, never chasing the glory, but always committed to fairness. After partition, Justice Khanna labeled his career in Delhi and eventually rose through the ranks to become a judge of Punjab High Court. In 1971, when he reached the Supreme Court of India, it was his quiet strength that would be tested as the most turbulent moment in India's democratic journey. During the emergency declared by the Prime Minister Indira Gandhi in 1975, civil liberties were suspended, censorship was imposed, and thousands were jailed without trial. The Supreme Court, which was considered to be the only last hope for countless citizens, in ADM Jabalpur versus Shivkant Shukla, the question that arose for consideration was hauntingly simple. Did citizens have any right at all when the emergency is in place, or whether all the fundamental rights, including the right to life and liberty, stand suspended? Could someone be detained without trial, seek judicial relief? 4 of the 5 judges on the bench answered in the negative, saying no. They ruled that during emergency, even the right to life and liberty under Article 21 could be suspended. Only one judge stood in dissent. It was Justice Khanna. Alone, he wrote a judgment that has since become a moral compass for the judiciary. He declared that the right to life is not merely a constitutional right, but it is a natural right, a human right. Even in absence of Article 21, the state cannot take away a person's life or liberty without authority of law. He called detention of trial an anathema to liberty and reasoned that the Constitution cannot be read as a license for state tyranny, even in exceptional times. He knew the cost of his dissent. At the time, he was the senior most judge and the natural successor to the most coveted post of the Chief Justice of India. But obviously, his judgment displeased the government and he was bypassed for the said post. A lesser man might have protested loudly or sought public sympathy. Justice Khanna chose silence. He simply resigned. It was not a resignation of defeat, it was an act of dignity. Even after leaving the court, he remained a quiet pillar of integrity. Thereafter, he chaired the law commissions, served briefly as a union law minister, wrote books that offered not just legal insight, but personal reflections on justice and fairness. His autobiography, Neither Roses Nor Thorns, remains one of the most honest account of a judge's life and thoughts. Years later, the very same judgment which he had dissented, ADM Jabalpur, was discredited. In 2017, the Supreme Court in the landmark privacy case not only overruled that verdict but acknowledged that Justice Khanna had been right all along. The words he wrote in isolation were finally embraced by the institution he had once served. His dissent became doctrine, his courage vindicated. We are celebrating his birthday today, and who can be a better speaker, because what has been told is a lecture series being organized in the name of Justice H.R. Khanna, and this is to start today. The organizers of this series have rather we can say righteously chosen a person like Justice Abhay Oak, the retired judge who has retired just a few days back. But if you look at his journey, I'm a silent follower of Justice Oak, and I have been watching all the lectures that have been delivering, and you can just applaud for his energy, what he possesses. And despite his retirement, he's awfully busy with the lectures which he's delivering in the Judicial Academy as well as in the colleges. Justice Oka, who is widely regarded as one of the most principled and courageous judges in the recent judicial history of India. His judicial career reflects a consistent commitment to the constitutional value, civil liberties, and independence of judiciary. His steadfast approach to the constitutional interpretation and his judgments have always displayed clarity, fairness, and fidelity to the text and spirit of the Constitution. He has upheld the importance of federalism, judicial independence, and procedural fairness across a range of cases. Justice Oka's legacy is not to be defined by volume, but by the depth which he possesses. He is a believer that judiciary must remain the first line of defense for the voiceless and the vulnerable. His contribution to service law, administrative law, and constitutional governance will continue to guide the future benches and the judges like me. What distinguished him from others was not only his legal reasoning, but the conscience with which it was applied, an insistence that justice must be done and seem to be done, regardless of how powerful the party before the court may be. We all are eager to hear Justice Oka on a very important topic of which is of great significance, that is independence of the judiciary. I must say that judicial independence is not a privilege of judges. It is a very foundation of the public trust in the judicial justice delivery system. It guarantees that every person who walks into the courtroom, regardless of his wealth, power, status, position, or popularity, will receive a fair hearing under the law. This independence must be both institutional and personal. At the institutional level, judiciary must be structurally insulated from other organs. The doctrine of separation of power, as envisaged by the constitutional thinkers, in my view, is not merely a theoretical construct, but it is a living mechanism that will ensure that not one branch becomes so powerful to overwhelm the others. We are definitely going to be much enlightened after the lecture delivered by Justice Oka. I am thankful to the organizers to invite me here. Thank you very much.
Thank you, Honorable Mr. Justice Bharti Dangre. It is pure happenstance that your stint here in Goa as a senior judge of the High Court of Bombay at Goa coincides with an occasion of this nature. And we were eager to hear you as well on this topic. And we are also grateful for your support for organizing this function. May now request our learned Advocate General, Senior Advocate Devidas Pangam, to address the gathering.
His Excellency, the Honorable Governor of Goa, Honorable Justice Dangre, Honorable Justice Menezes, Honorable Justice Mehta, retired Judge of the Honorable Supreme Court, Justice Oak, President of the Bar, other members of the Bar, distinguished guests, ladies and gentlemen, a very good evening to all of you. It is indeed a privilege to be a part of this august gathering on this special day, the birth anniversary of Justice H.R. Khanna. A lecture dedicated to the theme of judicial independence feels especially fitting given that Justice Khanna himself stood as a resolute symbol of that very ideal. The principle of independence of judiciary is a deeply enshrined in our constitution, and a judicious ethos is not merely a structural doctrine. It is a very soul of justice and fairness. When we speak about independence of judiciary, the immediate thought that comes to our mind is a freedom from political influence, and rightly so. Our constitution, through its careful crafted provisions, insulated judges from political pressure. It provides security of tenure, service conditions are fixed, the threshold of removal is deliberately kept very high. This institutional independence is not a gift, but a deliberate constitutional guarantee. It is a cornerstone of doctrine of separation of powers. Indeed, to large extent, this form of independence is preserved. Our courts have, time and again, reason to protect the constitutional values. Whether it is for the defense of civil liberties during the time of emergency or the vigilant guardianship of fundamental rights, the judiciary has shown its strength to remain unswayed. But the Conversation cannot end there. True judicial independence also requires freedom from within, from the invisible hands of one's own prejudices, from the unconscious sway of personal opinions, from biases that may cloud objectivity. This is the subtler and, in many ways, the more formidable challenge. A judge does not merely interpret law, a judge embodies the law. Therefore, the demand placed upon the judiciary is not only to act independently, but to think independently, to rise above political ideology, religious beliefs, social conditioning, and personal inclination. This is not a call to abandon human instinct, but rather a reminder that judicial office demands a constant striving, a continuous endeavor to uphold only the written word of the law and nothing else. In this, judges must follow a kind judicial asceticism. They must disengage from ego, rise above emotion, and must remain free from external influence. The great jurist Justice Holmes once remarked, "The life of law has not been logic, it has been experience." But in a constitutional democracy, it would submit that the life of law must be disciplined experience, filtered through neutrality, fairness, and fidelity to the Constitution. Ladies and gentlemen, judicial independence is not an abstract idea. It is the oxygen of free society. Its erosion begins not with grand betrayals, but with small compromises. When discretion overtakes discipline, when assumptions override analysis, when the judge forgets that the bench is a solemn space for restraint. It is the shared responsibility of both the bench and the bar to uphold the sanctity of judicial institution. As a member of legal fraternity, let us honor the dignity of the rope not only by guarding it against external pressures, but also by remaining mindful of our own conduct and influence. In doing so, we do not merely protect the judiciary, we protect the republic. Thank you very much. Jai Hind, Jai Gomantak.
Thank you, Advocate General, for your thought-provoking address. We have a very special, distinguished, and multifaceted chief guest. May I request Advocate Priyanka Kamath Setia to kindly introduce the chief guest for today's function.
Honorable Governor Shri P. Sridharan Pillai, Honorable Justice Bharti Dangre, Honorable Justice Nivedita Mehta, Honorable Justice Valmiki Menezes, Mr. Justice Abhay Oak, Honorable Retired Judge Supreme Court of India, Senior Advocate Devidas Pangam, Learned Advocate General for the State of Goa, members of the bench, senior advocates, respected dignitaries, and all the guests present here. It's my honor and privilege to introduce a multifaceted personality whose contributions span across the realms of law, literature, governance, and public service, Honorable Governor of Goa, Shri P. Sridharan Pillai. Born in Venamini Panchayat of Allappuzha district, Kerala, the Honorable Governor has had a distinguished journey rooted in scholarship, activism, and leadership. A graduate in arts from Pandalam NSS College, he went on to complete his law degree from Calicut Law College in 1978, where he actively participated in student leadership and editorial work, notably voicing strong opposition to the emergency through his writings. A respected legal professional, Honorable Governor has served as Senior Central Government Standing Counsel and CBI Standing Counsel at the High Court of Kerala, President of the Bar Association, Kozhikode. In the field of politics and public service, Honorable Governor has held numerous prominent roles, including multiple leadership positions in the BJP Kerala unit from district president to the state president, member of the BJP National Executive, and Central Prabhari for Lakshadweep, where he helped establish the party's presence. He served as the 21st Governor of Mizoram from 2019 to 2021 and is currently the 22nd Governor of Goa, having taken office on 15 July 2021. Apart from his exemplary service in law and governance, Honorable Governor is a prolific bilingual author who has penned over 200 books in Malayalam and English, covering a wide spectrum of themes: legal, political, poetic, historical, and cultural. His thoughtful and engaging writing reflects a deep concern for justice, democracy, and the cultural soul of our nation. Honorable Governor's commitment to public discourse has been recognized with the award of Doctorate of Literature by JJ University in 2020. On the personal front, he is supported by a family deeply committed to professional service. His wife is a practicing lawyer. His son and son-in-law are both lawyers at the High Court of Kerala, while his daughter and daughter-in-law are specialists serving in the medical field. It is a matter of a great honor for all of us to welcome a true scholar, public servant, and literary torchbearer, the Honorable Governor, Shri P.S. Sridharan Pillai. Thank you.
May I request the Honorable Chief Guest, Honorable Governor, Shri P.S. Pillai, to kindly address the gathering.
Honorable Justice Abhay S. Hoka, Justice Mrs. Bharati Dangre, Senior Advocate Devidas, Senior Advocate Kulhu Pereira, Advocate Shivam Desai, Honorable Sitting Judges of this High Court bench, senior lawyers, and my dear friends. I'm extremely happy to attend this function because during the time of emergency, I was a student activist in Kerala, and as far as emergency is concerned, I'm very much practical problems faced at that time in my mind, and of course regarding that aspect, about 1 month back, there was my own experience. I asked one of the law college professors, I'm not mentioning the name, to interact with me. Then I talked about Charkhanna. I want to do something. My discretionary fund I want to use for that purpose. Then, unfortunately, that professor was not having any idea regarding Charkhanna. Then I talked to Advocate General, and 2 other law colleges are here. Some amount from Governor's discretionary fund, I set apart that amount for Charkhanna's memory. And I thought of some library expansion or something may be used. Now I am very happy that this type of function is the starting of a very good, I am very happy to say that Charkhanna's for memory, this bar association is doing a very good job. Now I feel that I am still the part of legal fraternity. My family also, they are continuing after 2019, I became the governor, and then my family members, my wife, my son and my son-in-law, all are running my legal firm in Cochin. So even after my retirement from this job, I'm seriously thinking I will be I will be the only person who is going to practice in the courts. Because during the time of emergency, our Supreme Court, so many examples are there. My time is only 15 minutes, so I don't want to take that. Palkiwala, thrown away I'm using the word thrown away with great care. The wakalat of the person responsible for declaring emergency. And some other lawyers also, Bombay, at that time, there was a solicitor, he also resigned from that post. And so that incidents are there. As far as HR Khanna is concerned, you see, when this ADM Jabalpur case was referred by the welcome speaker, you see, HR Khanna, while sitting, he was the senior most judge. Of course, Chief Justice was also there. Put a question to Attorney General at that time, Mr. Nirande. He posed a question. Suppose a police officer taking a person to custody, legally taken to custody, and thereafter, because of his personal enmity to that person, if he's murdered or is beaten and murdered, can this court interfere? Nirande's answer, recorded by so many books, that no, you can't interfere. This court can interfere unless and until the emergency is withdrawn. So this is the basic thing happened at that time. You see, Charkanna, in his autobiography, on the previous day of ADM Jabalpur judgment, he was in Rajasthan guest house, and he didn't talk to his wife. He called her sister, told that tomorrow I am going to declare my view through this judgment, and thereafter I am going to lose my Chief Justice of India. And further he added that sometimes I will be a detainee under MISA. This was I am just referring this aspect alone. But at the same time, you see, after emergency, Shah Commission report and other things came into the public arena. Then nobody, Indian legal system, as far as lawyers are concerned, the most important lawyers in India were reluctant to accept the brief of the previous Prime Minister. Then immediately you see who has given advice to Srimati Gandhi. Her son Sanjay Gandhi and one A.R. Antule both went and meet him, and as per the advice of H.R. Khanna, the legal fight continued in India. So this shows our system, our rule of law, our constitution, and its impact in the society. Now I can say very well that our constitution during the last 75 years smoothly running, and we just think about other countries. What about Ceylon? Now Sri Lanka. What about Pakistan? What about other countries? Burma, Nepal. When our constitution was framed and passed by our parliament, Ivor Jennings, the most famous constitutional expert in the world at that time, he visited India, and Madras. There was a 2 days discussion on our constitution. He ridiculed our constitution. It is not fit for anything. But at the same time, I would like to say one thing. He drafted Ceylon constitution at that time. It is not completed 10 years. He drafted Nepal constitution. Fate was not different. So our constitution still existing. Of course, the various political parties, different opinions are there. It's got natural. Right to differ is the basis of democracy. But as far as the threat of our democracy at that time, If you go through the parliamentary proceedings in between 1970 to 77, we can very well see on behalf of the ministry, Senior Kumaramangalam, in the parliament publicly asked for committed judiciary. Then added to that, an American journalist, while interviewed the Prime Minister at that time, Honorable Prime Minister also in 1970s stated that democracy is an impediment on the activities, progressive activities. And there was a speaker in parliament, I'm not mentioning his name, asked why not we nationalize our press just like in USSR? And the shouting squad was there. That is a different opinion. It was there or not. I am not going to that. Shouting squad was inside the parliament for opposition leaders are speaking. These things are there. Other with respect to other things, Honorable Justice already stated its impact. You see, a newspaper preparing its news items and completed that draft and other things. In a situation wherein that item may be given to the censorship officer in the collectorate in the midnight or 11 o'clock or midnight, then only you can publish that newspaper. Only news items agreed by the setup executive or whatever maybe. I am not going to political, my limitation I know. So this was a situation. And 3 bills were passed in 1975-76. One parliamentary proceedings you can publish without the concurrence of, without the approval of the government. Another is also like that. In 77, all the 3 bills were withdrawn. Another situation is always known to us. I am stating all these things. I don't know whether politically or whatever, maybe I will be able to criticize that aspect also. Because now 50th year of emergency declaration, I have prepared 2 books. One is Democracy Enchained, Nation Disgraced, and other is with respect to the buried Constitution, buried Shah Commission report. So in a country wherein Shah Commission report was buried without even a single copy, then you see Eracharian, one of the founders of the DMK party in Tamil Nadu, 5 persons were there, he was one among them. Then he went to Australia, collected the copy, and his famous book in 2010, he published that book. At that time he was 88-year-old. That is Shah Commission Lost and Regained. These are things all happened in our country, and that is why right to life and liberty stood abrogated. And regarding these aspects, of course, the person who declared emergency withdrew that emergency before she was resigning from the prime ministership. But the same people in 1980 given verdict in favor of our prime minister also. So these are the things to be, we can see. I am as a student of history and law, I can say South Indian people as a whole, Kerala, in 1977 election, you see, 20 were given for autocracy and other things. According to me, it is autocracy. A different view can be taken by anybody. And in Tamil Nadu, 39 seats are there, and out of that, 34 were given to that political setup and including ADMK. In Karnataka, out of 28, 26 was, the mandate was like that. In Andhra Pradesh, 41 out of that, 39 were given. In Goa, 1 each. Gomandak party got 1 and other things are there. At the same time, you see the ordinary people of this country, poor people of this country, it is called cowbelt states, 10 states in India. In 1971, if you look into the election results, you see 235 seats were there at that time. Out of that, 239 were given to the Prime Minister in 1971, his party, their party. 228. But in 1977 election, only 2 seats, these 10 states. Educated Kerala people, 20 years old, you see, educational position is more in Kerala. I'm thinking as a student of history, the protectors of our democracy, whether education is the criteria, all those things are there. Some research and some studies should be specific. In 1952, when a question was posed to Jawaharlal Nehru, when India got freedom, 1952 election was there. Posed a question by press people to Nehruji. 58% of the people of India, they are illiterate. They can write their name. If somebody write that name, they can read it also. Then Nehruji's answer was that the politician has to educate the mass. So teachers will have to teach the people what is the position. Who will teach them? These are all questions required to be answered for a better democracy. And HR Khanna is concerned, I would like to say one thing. He's an ideal person for protecting the democracy in the country. That is why his chief justiceship was denied. And in 1973, Keshavananda Bharati case also superseded 3 judges. And in 1975, after 75 emergency time, superseded HR Khanna. Then the question is, will look into that aspect also by some research scholars or somebody and give answer to that. And I would like to say, I'm not going to the details. And what was a judicial ethics or judicial propriety or statesmanship in the judges? I'm not criticizing anybody. 3 judges were superseded, unethical. Nobody can justify that. Then the 4th person was appointed as a chief justice. Ethically, morally, he ought to have denied that. The same thing repeated in HR Khanna's case also. These are all things to be looked into. The law of the land now is that ADM Jabalpur case was referred here. ADM Jabalpur case, the 4 judges took a view, and now the law of the land is disallowed by HR Khanna. So these are all things to be at least be academically be discussed in our country. And I'm very sorry to say that we are not applying our mind on these aspects. Autocracy, I say willfully, because you go through the history of autocratic countries in the world during the 200 years or 100 years. The massacre of the people. But in India in 1975, I would like to say information autocracy. Suppressing the truth reaching to the people, prevented by the rulers, and then saying everything for the betterment of the people. Emergency also, the greatest people at that time in India, through them, the rulers were succeed in saying that this is all for poor people. The other side is like that. That is why South Indian election results in 1977 and that 10 states, UP, Rajasthan, and so many states are there. So, educate the mass is the need of the hour, and I would like to say that that was the situation in my state, Kerala. 22 persons lost life. I have written a book in Malayalam at that time in 2017. Before become the assuming the governorship, I have written another book, Dark Days of Democracy. It was released by our Honorable Prime Minister of India in 2017. Now also two books are there. Anyway, one copy I will give it to my best friend for two books, and we will study about all these things. And I am very much unhappy that a professor of a law college who is teaching the students not aware of about our HR Khanna, unfortunate situation that there. So my heartiest compliments to the Goa High Court Bar Association. I'd hope that this exercise of remembering legal luminaries will continue over the years, and the rich tradition of our judiciary as an impartial and independent pillar will continue to shine and flourish in our vibrant democratic country. Jai Hind, Namaskar to all.
Thank you, Honorable Governor Sri Pillai. The Goa High Court Bar Association will be eternally grateful to you for your gesture, which led to this initiative. Although I must say that I was quite baffled that anybody even remotely associated with the legal profession wasn't aware of Honorable Justice Khanna. But on the occasion, and since we have a lot of students here, I'll quickly give a hack. There is a, so that you don't have this eventuality ever in future, there is a fantastic book, is Constitution in the Making, which is dedicated to Justice H.R. Khanna. It is all the three judgments which are penned by him, that is Keshavananda Bharati, Indira Gandhi vs. Raj Narayan, and the habeas corpus case. And then it has a compendium of his articles on Constitution, which will just indicate the constitutional philosophy of Honorable Justice Khanna and the depth that Honorable Justice Khanna possessed. Well, now for the keynote address, may I request Advocate Vivek Rodriguez to kindly introduce our keynote speaker.
The Honorable Governor of Goa, Shri P.S. Sridharan Pillai, Honorable Judges of this Honorable High Court, Honorable Justice Bharti Dangre, Justice Valmiki Menezes, Justice Nivedita Mehta, retired judges of this court, District Judges, the Learned Advocate General, Senior Advocate Devidas Pangam, the President, Senior Advocate J. Coel Pereira, Senior Advocates here, my dear colleagues, and all those of you present here. 15 years ago, in the year 2010, I was a Raw Junior, just about 4 years in the practice. And I was witness to a senior judge visiting our beautiful High Court premises we had in Altino. And on the first Monday, admission day, I remember the senior judge making a statement that on Thursday and Friday, I am only going to listen and take up MACT matters and land acquisition matters. His statement followed, the corporate matters, the corporates have a permanent existence, whereas the existence of the families of those who are waiting for that compensation is determined by what they get from our courts. Ladies and gentlemen, I am honored to introduce to you our keynote speaker in keeping with the theme of Justice H.R. Khanna. It is none other than that very same gentleman who adorned the bench, Justice, retired judge of the Honorable Supreme Court of India, Justice Abhay Ok. Having dabbled in the chambers of Shri V.P. Tipnis and having a huge practice with a focus on PILs, he gave up the same and became a judge of the Honorable High Court of Bombay in the year 2003. He assumed the office of the Chief Justice of Karnataka High Court in 2019. and thereafter took oath as Honorable Judge of the Supreme Court of India in 2021. Well, throughout this illustrious journey, he is and will always be known for his humility and how he could relate to the grassroots levels of society. None other and no other better person than to have the first keynote speak for this H.R. Khanna, Justice H.R. Khanna Memorial speech. Can I request you, sir? His Excellency, the Governor of Goa, Shri P.S. Sridharan Pillai, Honorable Justice Mrs. Bharati Dangre, sister and brother judges of the Bombay High Court, Honorable retired judges of the Bombay High Court, Mr. Pereira, Senior Advocate and President of the Goa High Court Bar Association, the Advocate General of the State, office bearers of the association, senior members of the bar who are present here in large numbers, members of the bar, young students and young lawyers. I consider myself to be extremely privileged and lucky to be part of lecture series in the memory of late Hansaraj Khanna. Today, I am supposed to speak on independence of the judiciary. Since I am going to address you in the context of life and times of Justice H.R. Khanna, naturally the focus will be on the days of emergency. But to begin with, I must clarify that when it comes to independence of judiciary, irrespective of the party in power, irrespective of the fact whether there is emergency or not, there is always a threat to independence of justice, independence of judiciary. And therefore, the members of the judicial fraternity, namely the judges and members of the bar, have to be always alert and ensure that independence of judiciary is not affected in any manner. I remember to have read one article in New York Times. It was article dated 30th April 1976. It was editorial written perhaps 4 days after the judgment in ADM Jabalpur versus Shukla was pronounced. And very interestingly, in that editorial of New York Times, it is said, if India ever finds its way back to the freedom and democracy that were proud hallmarks of its first 18 years as an independent nation, someone will surely erect a monument of Justice H.R. Khanna of the Supreme Court. That's what New York Times says. His monument was not erected. His portrait was displayed in Court Hall number 1 of the Supreme Court. And for me, it was not necessary to have monument of Justice H.R. Khanna because he will be forever remembered for what he did for upholding the independence of judiciary and independence and also fundamental rights of the citizens. But for his supersession, he would have become Chief Justice of India on 29th of January 1977 and would have occupied the office till 2nd of July 1977. But I must also say here that there are judges and chief justices of the Supreme Court who have been already forgotten. But there are a large number of judges of the High Court who never went to the Supreme Court and they are remembered forever. There are judges of the Supreme Court who did not become Chief Justices of India, but they are remembered forever. Giving example of our Bombay High Court only by a Felicitation, we had Chief Justice M.C. Chagla, Justice Chittatosh Mukherjee, Justice P.D. Desai, Justice M.L. Pense. These great judges never went to the Supreme Court, but we fondly remember them. I can add many names to that, like Justice Vima Dalal, Justice Lentin, and so many other names can be added. Same is the case with Supreme Court judges. Everybody knows, we remember H.R. Khanna. We remember Justice Vivian Bose. We remember Justice Krishna Iyer. We remember Justice J.R. Mudhalkar, who much before Keshavananda Bharati has written about basic structure of the Constitution. We remember Justice Hegde, Grover, and Shelat, who were superseded. Since we are in the context of days of Justice H.R. Khanna, I want to start with Keshavananda Bharati. Keshavananda Bharati, of course, all of you know. The basic concept of basic structure of the Constitution introduced by that judgment by majority. I want to tell this for the benefit of the students and young lawyers that I personally feel as a student of law that this is one judgment which kept democracy in India intact. And there are fascinating stories about this judgment. Within 3 days of the pronouncement of the judgment, 3 judges, Hegde, Shelat, and Grover, they are superseded. And that paved way for Justice Endeavour to become Chief Justice. I must tell you one more thing. When the emergency was proclaimed, there was only one survivor of the majority view in Keshavananda Bharati, that was Justice H.R. Khanna. There is something interesting about Keshavananda Bharati. I'm not going to repeat what was held in Keshavananda Bharati. I leave it at that by saying that it is one judgment which even today continues to protect the democracy in India. As a consequence of supersession, Justice Ray became Chief Justice of India. In normal course, he would not have become Chief Justice of India because perhaps he would have retired during the tenure of Justice Grover. I believe in November 1975, he suddenly constituted a bench of 13 honorable judges of the Supreme Court for the purposes of reconsidering or reviewing Keshavananda Bharati. And I read that famous argument by Nani Palkhiwala that he told the bench that the case before you does not involve basic structure at all. And advocate generals of various states said that nobody has requested for review. Very vivid account of what exactly happened before that bench is mentioned by Justice H.R. Khanna in his autobiography. It is worth reading. And ultimately, the bench was dissolved. This is very significant to be remembered by students of law. And look at the sacrifice involved. 3 judges had to forgo the post of Chief Justice of India. I remember this year in 25, as a Chancellor of National Law University at Sambhajinagar, I had arranged lectures by eminent speakers on the Constitution of India. Very eminent speakers spoke there. One of the eminent speakers pointed out something which I was not aware. In 50s, one of the senior judges was told by the then Prime Minister Jawaharlal Nehru that by superseding the senior most judge, he will be made the Chief Justice of India. I am told the judge was Justice B.K. Mukherjee. Within split second, his answer to Honorable Prime Minister was that if you do that, I'll step down. These are the stories of sacrifices. These are the stories of principles of Supreme Court judges of those years. And surprisingly, the supersession was defended by, on behalf of the government in Parliament, by S. Mohan Kumar Mangalam. And what he said today may apply, is relevant even today also. I must say this with great deal of responsibility. What Mohan Kumar Mangalam in Parliament said while defending the supersession, he said that as government, it is our duty to take philosophy and outlook of judge before he is appointed as CJI. This was completely against the ethos of our Constitution. Parties may come and parties may change, but this kind of philosophy, this kind of thinking remains, whether in small or large form. Before I go to Justice Khanna's supersession, I must say that the then Law Minister H.R. Gokhale defended that supersession on the floor of the Parliament by saying that if Justice Khanna would have been made Chief Justice, he had short tenure of 5 years 5 months. As against that, Justice Beg, who was made Chief Justice, had tenure of 11 months. Now, this was the thinking of the people in power. Then comes the case of the famous case of ADM Jabalpur versus Shukla. Before I deal with that case, as we are talking about independence of judiciary, I want to tell with great deal of emphasis for young members of the bar and young students of law that even before Justice Khanna's dissent, at least 3 to 4 high courts took a very bold view. For the benefit of young students, I want to tell you something. Emergency was proclaimed on 25th of June 1975. On 27th of June, the President exercised power under Article 359 and directed and declared that remedies under the Constitution for enforcement of fundamental rights under Article 14, 21 and 22 shall stand suspended. Whereas at that time they had forgotten Article 19. So a similar order was passed in relation to Article 19, I believe, on 8th of January 1976. The argument before various high courts, I am going to talk about only Bombay High Court and of course Madhya Pradesh High Court. I believe it was Justice Sen who had taken the view that habeas corpus petition was maintainable, and that led to the famous judgment in the case, famous or infamous judgment in the case of ADM Shukla. In Bombay High Court, there were bold judges. There was one judge who dealt with a case where the government did not permit, the Commissioner of Police did not permit a protest meeting to be held for protesting against the emergency. And notwithstanding suspension of remedy to enforce Article 19(1), the learned judge boldly held that this is completely illegal. There are judgments, the very famous judgment by Justice Tulsapurkar. When I talk about this right to protest, this happened in emergency. I came across a case as Chief Justice of Karnataka High Court in 2020 or 2021 when somebody wanted to protest against CAA, Section 144 of CRPC was invoked. So in those days, the rulers may have relied upon the emergency powers, but the tendency continues, and I had to set aside that order which prohibited agitation against the CAA. There was one more very famous judgment by Bombay High Court, and that judgment is worth reading, where the government advocate stands up and makes an argument that tomorrow, if order of preventive detention under the MISA, Maintenance of Internal Security Act, says that the detainee should not be provided food, even in that case, he cannot maintain a petition under Article 226. Consistently, Bombay High Court, at least 4 judges, I think Justice Vima Dalal, Justice Tulsapurkar, Justice C.S. Dharmadhikari, they took the view that there is a rule of law. If an order of preventive detention is mala fide, if it is illegal, it is not within 4 corners of law, petition under Article 226 will be maintainable. There was a famous case, there was a Marathi weekly, very famous Marathi weekly, started by none other than a great socialist leader, Sane Guruji, who was follower of Mahatma Gandhi. About 11 issues of that weekly were forfeited by the government. Justice Tulsapurkar interfered and he said that this is something blatantly illegal, and Article 226 was invoked. There is very interesting thing the students of law must observe. See the combination of bench which dealt with ADM Jabalpur versus Shukla. Of course, Justice Dangre was the Chief Justice. And you will find that except for Justice H.R. Khanna, the other 3 who were part of the majority became Chief Justice of India. But Justice H.R. Khanna never became Chief Justice of India. I don't know whether any significance can be attached to it, but still it is worth considering. And then came that pronouncement of law by Justice H.R. Khanna. And I want to read only few
passages from his famous dissent. As Honorable Governor said, that when Justice Khanna wrote this minority view, he was fully conscious of the fact that he is writing that view at the cost of the post of Chief Justice of India. Please remember, I want to appeal to the young students, please remember the sacrifice made by him. Not only him, as I said, there are several judges who may not have reached the pinnacle. But if you look at the history of judiciary, there were attacks on judiciary. Those attacks continue even till today. But there were fearless judges who defended the judiciary, and their only object was to ensure that the democracy and constitution must survive in India. Now, very interestingly, what Justice Khanna holds here is that he says that Article 21 is not the sole repository of freedom. And that's a beautiful analysis made by him. Perhaps same analysis was made by Justice Tulsapurkar and Justice C.S. Dharmarikari sitting in Mumbai. What he says is in paragraph 530, even in the absence of Article 21 of the Constitution, the state has got no power to deprive a person of his life or liberty without authority of law. This is the essential postulate and basic assumption of the rule of law and not of men in all civilized nations. Without such sanctity of life and liberty, the distinction between a lawless society and one governed by laws would cease to have any meaning. The principle that no one shall be deprived of his life or liberty without the authority of law is rooted in consideration that the life and liberty are priceless possessions which cannot be made the plaything of an individual whim and caprice, and that any act which has the effect of tampering with life and liberty must receive sustenance from and sanction of the laws of the land. Article 21 incorporates an essential aspect of that principle and makes it part of fundamental rights guaranteed under Part 3 of the Constitution. It does not, however, follow from the above that if Article 21 has not been drafted and inserted in Part 3, in that event, it would have been permissible for the state to deprive a person of his life or liberty without the authority of law. Then he says, I am unable to subscribe to the view that when right to enforce the right under Article 21 is suspended, the result would be that there would be no remedy against deprivation of a person's life or liberty by the state, even though such deprivation is without authority of law or even in flagrant violation of the provisions of law. The right not to be deprived of one's life or liberty without the authority of law was not the creation of Constitution. Such right existed before the Constitution came into force. The fact that framers of the Constitution made an aspect of such right as a part of fundamental right did not have effect of the independent identity of such right and of making of Article 21 to be the sole repository of that right. I am unable to agree that in view of the presidential order in the matter of sanctity of life and liberty, things would be worse off compared to the state of law as it existed before coming into the force of Constitution. So therefore, ultimately what he holds is that the liberty existed even before Constitution came into force. It was essential part of rule of law, which is part of our jurisprudence. Now, you have to understand this in the context of days of emergency when Justice Khanna wrote this dissenting opinion. I referred to Justice J.R. Mudhalkar, I referred to Justice Vivian Bose, I referred to Justice Krishna Iyer, and many famous judges of the Bombay High Court. I want to tell for benefit of young members of the bar that what we learn from these great judges, or at least why I learned from them, I personally learned from them. Of course, it was very difficult for me to fully follow these great judges. But what I learned from these judges is that after a judge takes oath of office under the Constitution, he should never ever think about his future prospects. Wherever a case comes before him, He has to apply the law, he has to apply the constitutional principles and decide the case. He should not be bothered about what the powerful people will feel about that judgment or whether powerful people will get offended. And therefore, it is the duty of judges that they should not think about consequences of their judgments. Their duty is to see that correct judgments are delivered. And I want to tell this for the benefit of young lawyers and young law students who may be aspiring to join judiciary. I say so in every judicial academy. If you are bold and fearless, perhaps you may not get the higher post or you may get it very late. But what you get is a great satisfaction of abiding by your oath. Even the civil judges take oath of office, then that oath is as important as oath under the Constitution. So what is more important is the satisfaction you get that you have abided by the oath. The post and future prospects are completely irrelevant. We have completed 75 years of existence of the Constitution. Even after 75 years, rigorous efforts are required to protect and maintain the fundamental rights guaranteed under the Constitution. And most important of those fundamental rights are right to liberty under Article 21 and freedom of speech and expression. With Constitution or without Constitution, when it comes to freedom of speech and expression, I request the young members of the bar and young law students to read the address by Lokmanya Bal Gangadhar Tilak to juries of the Bombay High Court in famous sedition trial. I want to quote only one sentence what he says. He tells the jury that you are called upon to decide whether there is a freedom of press in existence in British India. And one very interesting sentence in the context of sedition, which Lokmanya has said, he says that I know that British government does not like me, but that does not mean that I should be tried for sedition. That's what he says. And he also says that merely because one person says that I have committed offense of sedition, it does not become sedition. So true even today. So today, when we think about the independence of judiciary, we have to think about why their judiciary should be independent. Unless we have independent judiciary, the fundamental rights will not survive, the democracy will not survive. And that's the importance of independence of judiciary. It is the judiciary. I'm not talking about only the freedom of speech and expression. It is the judiciary who has protected slum dwellers in Mumbai. It is the judiciary which took a view that slum dwellers may be in illegally occupation of slums, but they cannot be deprived of water. It is the judiciary which has taken care of poor and downtrodden, and they are under obligation to do so. We are not talking about, as I said, rights under Article 19, rights under Article 21 can be said to be more important. So therefore, when we have completed 75 years of independence, it is our duty, those who belong to the legal fraternity, to ensure that independence of judiciary remains intact. I'll give only one example of how sometimes, even as of today, we can say that independence of judiciary is under challenge. I'll give only one example because my time is almost over. That one example is now we have a collegium system. And fortunately, Justice H.R. Khanna's nephew, Chief Justice Sanjeev Khanna, has gone transparent, and every single document regarding how the collegium system functions is on the public domain. At every stage, right from the recommendation made by the Collegium of the High Court, at every stage, the state and the authorities have their say. The Chief Minister can raise an objection, the Honorable Governor can raise an objection. Then there is IB report. Now IB works under the Home Ministry. the IB report, there is a response of the government of India, which all comes up before the Supreme Court Collegium. And today we have a scenario where after the Supreme Court Collegium approves the recommendation, it is put on the website. It takes 9 months, 10 months, year for government approving the names of the judges. Once Supreme Court Collegium resolution is on the website, please imagine what will be the mindset of that person. He can't get the work. He feels that he's going to become a judge, but he has to wait for 9 months, 10 months, or even a year or more. Does it not affect independence of judiciary? I'm giving you only one illustration. And therefore, today we have a scenario where Chief Justices say that they sometimes find it difficult to persuade bright lawyers to accept judgeship. Of course, I must say that those who are accepted are also bright. But that's a practical difficulty which all the Chief Justices face because of this uncertainty. Therefore, we are talking about challenges in emergency. There were huge challenges because of the law which was prevailing. There was order under Section 3, Article 359. And there was censorship. I am told, I am not sure, I tried to find out material. Even the minority view of Justice Khanna was censored. It was not allowed to be published. That's what I read somewhere, but I could not get those orders. So the time differs. The persons in power are different, but ultimately it is irrelevant who is in power. There is always a tendency, a natural tendency on the part of those who are in power to tinkle with the independence of judiciary. And therefore, I thank the Goa Bar Association for starting a lecture series in the name of late Justice Hamsaraj Khanna, because every year when this lecture is held, we'll be able to convey message to the young lawyers, to the members of the legal fraternity, how important is judicial independence, how important independence of judiciary, and how important are the sacrifices made by judges, the great judges of those years. I close by quoting what Justice H.R. Khanna has said in his autobiography. And this, according to me, sums up what his philosophy was, what was his thinking. At one place in his book, he says, there arose a feeling of some satisfaction for having not faltered at the crucial time from what I believed was the correct course. The fact that it resulted in foregoing and losing the office of the Chief Justice of India did not hurt very much, for such consequence was expected from the moment I prepared my judgment in the habeas corpus case, and also because many others have paid much greater price for following the voice of their conscience. Undoubtedly, those moments were not without a tinge of sadness, which invariably is there at the time of parting, whether from a career of a life or from a dear one. It also happens that in such moments of crisis, in the moments when the curtain is falling on a major part of one's life, one has the consciousness of having done what one believed to be right thing. One gets sustenance and support from inner and hitherto unknown reserves of strength. See the humbleness of this man. He says that my sacrifice is nothing. The earlier judges have made much more sacrifices. And I think this one passage in his book sums up his philosophy, his thinking, his approach to the life. And I think if we read this passage, I think it will be education for young members of the bar and young students of law. I thank again, firstly, the Honorable Governor for his great act of generosity. I don't think I have seen any governor holding such important constitutional office helping to start lecture series in the name of a fiercely independent judge. So therefore, we must pay compliments to him. And again, compliments to Senior Advocate Pereira and his team And I hope and trust that this activity will continue. A trust is going to be formed, and I assure the members of the bar that whenever required, my contribution will be always there for any educational activity to start on behalf of the trust. Thank you.
Thank you, Honorable Justice Oka, for your eloquent and insightful address. All I would like to say is we were proposed a question answer session after this, but we are slightly running out of time. But I would take this occasion to extract a consent from you for an interactive section sometime in future, in the near future, because I'm sure the members of the legal fraternity and the students would love to have a dialogue with you on various subjects. But all that I can say is, when I say this, I speak on behalf of all those present here. There's something very endearing and compelling about the way you speak and the way you engage with all those who listen to you. So thank you once again. As I said, it's a significant day for the Goa High Court Bar Association, and to mark the occasion and as a token of appreciation of and gratitude, we thought we would felicitate or acknowledge and recognize the presence of the Honorable Chief Guest, Honorable Governor Sri Sridharan Pillai. May I request the President of the Goa High Court Bar Association to kindly present a souvenir to the Honorable Governor. Thank you, Honorable Governor. Thank you, President. May I request the Vice President of the Goa High Court Bar Association, Advocate Datta Prasad Lavande, former Advocate General for the State of Goa, to kindly present a memento souvenir to the keynote speaker for today's function, Honorable Justice Abayoka. And I would be failing in my duty if I don't make a special mention of Honorable Justice Valmiki Menezes. I think we, every time we had any kind of an obstacle in the organization of this function, I did mention Honorable Justice Dangre, but even Honorable Justice Menezes made sure that in his own nonchalant way, he just made sure that everything was set right. And Ms. Nivedita Mehta for her support. May I request Akshata Bhatt to kindly deliver the vote of thanks.
Honorable Governor of Goa, Shri P.S. Sridharan Pillai, Honorable Justice Srimati Bharati Dangre, Honorable Justice Sri Valmiki Menezes, Honorable Justice Srimati Nivedita Mehta, Learned Advocate General of Goa, Senior Advocate Sri Devidas Pangam, Honorable Justice Sri Abhay Oak, Retired Judge, Supreme Court of India, President of the Goa High Court Bar Association, Senior Advocate Sri J.E. Coelho Pereira, esteemed members of the Goa High Court Bar Association, ladies and gentlemen, good evening. On behalf of the Goa High Court Bar Association, it is my privilege and honor to extend a heartfelt vote of thanks at the conclusion of this enlightening lecture program. We are truly privileged to have been graced by the presence of Shri P.S. Sridharan Pillai, the Honorable Governor of Goa. Sir, your presence today has been a great source of encouragement and inspiration to the legal fraternity. Our sincere thanks to Honorable Justice Srimati Bharti Dangre, Honorable Justice Sri Valmiki Menezes, Honorable Justice Srimati Nivedita Mehta for honoring us with their esteemed presence. We are thankful to Learned Advocate General of Goa, Senior Advocate Sri Devidas Mangam for his esteemed presence. A very special note of gratitude to Honorable Justice Sri Abhay Oak for the thought-provoking and insightful address on the independence of judiciary. We are grateful for the clarity and depth with which you address this foundational principle of our democracy. I also take this opportunity to thank retired judges of the High Court of Bombay at Goa and senior advocates for joining us today. A big thanks to the President of Goa High Court Bar Association, Senior Advocate Sri J.E. Coelho Pereira, and the dedicated committee members for their tireless efforts. A heartfelt thanks to my colleagues at the bar, the students from the law colleges, the staff of the High Court, the media, and all those who work to ensure the success of this program. May the insights and ideas shared here today continue to inspire and guide us in our shared commitment to uphold the independence and dignity of judiciary. Thank you.
And last but not the least, I must thank all those who are present here in large numbers. I know you all were, some of you were inconvenienced, but I really appreciate the fact that everyone has stayed on. And the Goa High Court Bar Association really acknowledges that. Can we have the national anthem? May I request everyone to rise for the national anthem?
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविण उत्कल वंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाए तव जय गाता जनगण मन अधिनायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.